The Court of Appeals is now in session.
All right, good morning and welcome to the Utah Court of Appeals virtual edition. I'm Judge Ryan Harris, and with me today on the panel is Judge Greg Orm and Judge Diana Hagan. We're happy to be here today with you. The first thing I want to do is have counsel introduce themselves, make a record of who they are and who they represent, and then I'll have a few more remarks and then we'll get started. Start with counsel for the appellant. You're muted, Ms. Nelson.
We'll try again. Julie Nelson, counsel for appellant Jerry Brown.
Good morning. Thank you for being here.
Thank you. And Spencer Brown of Strong and Haney, counsel for appellee Yvonne Brown, with is Ron Haycock of my firm as well.
All right. Good morning to you as well, Mr. Brown. We're glad to have you here with us.
Thank you.
Now, let me ask, have you participated in a virtual hearing with us since April? Yes or no?
Yes, Your Honor.
I did the Supreme Court in April.
Okay, so you guys know the ropes, and I'll truncate my remarks otherwise. It helps if you leave it on grid view. That way you can see all of us plus the clock. The clock will appear in Lisa Collins' box. It says 11 minutes right now. I assume that's because, Ms. Nelson, you've communicated with Ms. Collins that you'd like to reserve 4 minutes for rebuttal?
That's correct.
Okay. And when it's your turn to speak, obviously you'll have your video on and you'll have your microphone on. But when it's not your turn to speak, we'd ask that you turn your video off and your microphone off so that we can concentrate on the attorney whose turn it is to stand at our virtual podium. If you do that, we'd appreciate it. If we have a question, and sometimes we do, you'll see us first unmute our audio. We'll keep our audio muted as well unless we have something to say. So you may notice the little red mark disappear. That's your first clue that one of us may have a question. Your second clue is going to be some sort of visual signal from us indicating that we have a question. We'll try not to just jump in and talk over you. That turns out to not make a very good record. So if you wouldn't mind keeping an eye on that so that if we have questions, we can get them asked and answered without talking over each other. If you lose audio or video for more than a few seconds, that's a problem. If you lose video, obviously we'll be able to tell. If you lose audio, let us know. We may need to go back and recreate a few seconds of something if somebody lost audio. If it gets really bad and you lose everything, then send Lisa a text or an email, and we'll have to figure out how to proceed from there. Any questions about our procedure this morning?
No, Your Honor.
Okay. We've had pretty good luck with it since April when we started it. We'll hope the good luck continues today. And we'll turn the time now over to Ms. Nelson as counsel for the appellant, and we look forward to hearing from you both this morning.
Thank you, Your Honor. Good morning. Julie Nelson for appellant Jerry Brown. The general rule in Utah is that separate property remains separate unless one of three exceptions is met. And I just want to quickly recap the rule to make sure we're all on the same page. The three exceptions are commingling, the contribution exception, and equity. The trial court here relied on the contribution exception, which itself has three subparts. One is when the non-owner spouse makes a prudent investment of the separate property, not at issue here. Another is when the non-owner spouse works for the spouse's business and forgoes compensation, not at issue here. And the third, the one that the trial court used, was when marital funds are expended or marital debt is incurred for the benefit of one spouse's separate property. Let's talk about those two things separately. One is whether marital debt was incurred. That did not happen here, and there's no allegation that it did. In Schomburg versus Schomburg, the husband owned a separate property. He took out a $25,000 loan from a third party, which at the time of divorce, he claimed was a marital debt, and the wife should be responsible for half of it. Because that was a marital debt that had been incurred to benefit the separate property, that $25,000 was spent on the separate property, the trial court and this court affirmed that that meant that the separate property had become marital property. That didn't happen here. The loans that Jerry used at all times were loans from Cascade Dental. The next issue is whether marital funds were expended. No marital funds were expended in this case. At all times, Jerry Brown owned Cascade Dental. He had owned it before he married Bonnie. He had owned it while he was married to his previous wife. He had paid off the building and the loan before he married Bonnie. And all of the money from the clients and the insurance companies came into Cascade Dental's accounts, where it stayed. It paid the hygienists. It paid the hygienist salaries. It paid for the machinery. It paid for all of the supplies that a dentist office needs. It paid for the rent, the taxes, and it paid Jerry's salary, and it paid Bonnie's salary, and money was also withdrawn regularly to pay for marital expenses. Now, it's worth saying that Cascade Dental, or Jerry Brown DDS, however we want to refer to it, was an S corporation. An S corporation, this is not important legally, but it helps understand the setup. An S corporation is an IRS tax arrangement that allows a small business owner to pay himself a small salary and also allows him to make withdrawals or draws and reduces the amount of self-employment tax that he has to pay. So it's a perfectly legal and very, very common way to run a small business. Now that's what was happening here. Jerry was using money coming out of Cascade Dental to pay for marital expenses. But at no time did marital money go back into Cascade Dental. Those dollars were Cascade Dental's dollars until they left. Once they left, they became marital dollars, but they never returned. So we cannot say that marital funds were expended. Judge Hagan, was that a question?
And as I understand your argument, you don't have any quarrel with the district court's finding that your client had significantly more income than he had been the $6,000 salary that he drew, because he was drawing all of that for personal expenses. So as I understand your argument, all the money that was withdrawn for marital expenses would have all obviously affected the alimony amount, but just in your view does not affect whether the actual dental practice was marital property. Is that right?
That's absolutely right. And I think that's really important because we don't disagree that the money coming out set the marital standard of living. The alimony was premised on that income. So it's important to keep in mind that Bonnie did receive the benefit of Jerry's income because she got it through her marital standard of living. She also got it because she got half of the assets that the marriage bought. But what Bonnie asked for was not half of, say, any particular part of the dental business. She asked for half of all of the dental business. Its building, its x-ray machines, its chairs, everything that it owns, things that Jerry had had and had accumulated over time. So you're right. I'm not talking about the income. I'm only talking about the dollars that remained inside of Cascade Dental's bank accounts. Does that answer your question? The primary case that my opponent relies on is Kiter versus Kiter. Kiter is not like Brown at all. In Kiter, the husband was a doctor, and he had separate income and he had marital income. And he deposited them into the same accounts without any sort of division. He had marital accounts, he had business accounts, he had retirement accounts, and he just put the money in there indiscriminately. And importantly, he also paid not only his family expenses, but his business expenses indiscriminately out of those accounts. It reminds me of the tap, the hot water and the cold water both coming in. And then in Kiter, they left separately, but everything got gathered together in the basin, the hot and the cold water together in the basin. That didn't happen here. Everything stayed in Cascade Dental's accounts until it left. So it's simply not true that marital funds were expended for marital property. Now, there is one case that gives us pause, and that's Keys versus Keys. In Keys versus Keys, it is not a holding. And it's important to note that my opponent has not relied on this case at all. But in Keys versus Keys, the husband had a premarital landscape business, and the wife asked for half of its inventory, not half of the business, but half of the inventory. The trial court never gave a reason as to why the wife would be entitled to that premarital inventory. And this court stated that it couldn't It couldn't affirm because there were no findings. It reversed and remanded for further findings. And it said simply as like a side note that one of the possible theories could be that the wife complained that the husband had artificially suppressed his income. Well, that's not what happened here. What happened here was that twice Jerry decided to augment his separate property with his separate income. Once he renovated, and once he tried to expand into a second office. Well, Bonnie claims that it affected how she traveled and that she had to sacrifice financially during that period. Meanwhile, she was living in an $860,000 house. We know about the cars that they drove. We know about the things that they purchased. It's difficult to see how she sacrificed financially. It's not clear from Keyes, which again is not a holding, but it's not clear from Keyes that if any money is spent to build the separate property, that automatically turns the separate property into marital. In fact, that would be a terrible policy. That would make it so that it was almost impossible to keep your sole business separate. That sounds like we're talking about a bank account that never gets touched. But what we want here is the ability of a person who has separate property, a person who inherited it or maybe married later in life and had already built it. We want that person to be able to maintain their separate property, but also gift some of it to the marriage, use it to benefit the marriage, not always squirrel it away, but not at risk of changing the identity of that property from separate to marital. We have no cases that suggest that a sole business should become entirely marital simply because somebody uses part of it to build up the separate, to augment the separate property. I'd like to point you to footnote 1 of Schomburg, which simply says, nor do we suggest that payment of a legitimate business expense related to the value or use of an inherited asset converts that asset or a portion of that asset into a marital asset. Surely that rule applies to a business, that the payment of a legitimate business expense related to the value or use of it does not convert that into a marital asset. I'd like to spend my last 2 minutes talking just about our second issue. Bonnie was awarded $96,000 in her pre-decree expenses. And the trial court stated that she was entitled to access to the marital estate. This issue is very important to my client because he feels that she did receive half of the marital estate. She received the $100,000 that they refinanced from the building. And let's keep in mind that that money wasn't sitting in a bank account. They had to refinance it. And so Jerry kept making monthly payments on it, but he wasn't given any credit for that when it came to the pre-decree expenses calculation. He also paid for a $200,000 laser that she took with her. He made monthly payments on that every single month during their separation, and he was given no credit for that. Judge Harrison.
Can you respond to the argument they made that some of the laser and some of the other equipment that you point to in this part of your argument was part of a business that he was a partner of?
I think that the important point is that she took all of that and she also received the benefit of the laser itself and all of those payments. So whether they were separate or marital doesn't change. I mean, your point is that it was a business that he was part of. My point is that when we're talking about dividing up the marital estate and making sure that everybody has access, she did have access, right? She was getting these enormous things paid for. The fact that she chose not to use it for her food or her clothing or her rent, that's not Jerry's fault. That's her choice. I think we have a real problem when one person is paying debt for the other person, and yet the other person is allowed to just live high on the hog and get all of that money back. Yes.
Yeah, I just had a question about, it's a follow-on to Judge Harris's question. I understand from the briefs, and correct me if I'm wrong, that he had a 10% interest in her business. Did he receive some kind of distribution or some share of what her business was worth when in the divorce decree?
I don't believe so.
And one more question for you, Ms. Nelson, before you sit down. On the second issue, I take it that part of your argument is that even if the district court was correct in assigning some value here. It incorrectly assigned 100% of that value and should instead have only assigned 50% of that value, because I think your argument is that money should have come out of the estate prior to division, rather than coming out of your client's half of the estate after division. Do I understand that correctly?
Right. Another way of thinking about it is that if it was truly a debt of the marital estate, a debt that Bonnie accrued, those debts should be divided equally, so that Bonnie bears half of it and Jerry bears half of it. At most, Jerry should be responsible for half of it, not for all of it. It doesn't make sense that Jerry's responsible for all of her expenses and paying for all of those other things that he paid. One final theory on that is that the trial court found that his ability to pay alimony afterwards was significantly lower than the monthly amount that it described here. And that doesn't make sense either. That shows that there simply wasn't enough money to meet all of Bonnie's expenses. And that's because Jerry was responsible for all of her expenses, all of his expenses, and also paying the debt on her expenses. With that, I'll reserve my time.
All right. Thank you, Ms. Nelson. We appreciate the argument. We'll turn the time over to Mr. Brown now.
Thank you, Judge Harris, and may it please the court. The court should affirm the award to Bonnie Brown of half the value of her husband's dental practice, because the practice lost its separate property identity and became a marital asset. This happened through essentially a two-step process that tracks what this court held in Kiter. First, this happened when Jerry Brown used his practice's account to pay more than $10,000 of his family's expenses every month during the marriage, and then used that account, which was marital money at that point, to pay for loans he took out to improve his business. Yes, Your Honor.
Why does it become, you said marital, that account became marital property at that point as soon as he took some of it and paid marital expenses with it? That's the argument?
That's the argument. And our argument, Your Honor, is that account lost its separate identity and became marital property because marital funds and separate funds were inextricably commingled at that point. Well, there was no type of accounting. Oh, yeah, sorry, Your Honor.
You lose me a little bit there because isn't there a distinction between an account on the one hand and the business itself on the other?
Yes, you're absolutely right.
There's dollars sitting in a bank account that is Cascade Dental's bank account, right? And some of those dollars get used to pay the mortgage and other household expenses, right?
Correct.
And I'm confess I'm just not really following the argument how use of the funds from that account to pay for certain household expenses turn the whole business into a marital asset. Can you help me understand how that bouncing ball gets to that point?
That's right, Your Honor. Use of that account alone does not turn the whole business into a marital asset. Use of that account indiscriminately without any proper accounting or any consideration of whether the family expenses should be paid directly from that account turns the account into a marital asset. Just like the husband's medical practice account in Kiter. What turns the business into a marital asset is the contribution exception that Ms. Nelson discussed just a minute ago. And what happened here is after Jerry had been using his funds month after month after month to pay the family's expenses without withdrawing those, without taking a draw from his S corporation, without taking a salary that was commensurate with his family's expenses. He then took out loans to expand his business and began paying those loans to the tune of $6,000 per month from that same account. So now he's taking the money that was a marital asset that was used to pay the family's expenses and is now using that to improve and to maintain his separate property. And, yes, Your Honor.
Now, I understand a moment ago you said he withdrew about $10,000 a month for to pay mortgages, obviously marital expenses. I think we're all on the same page there. Is there any evidence that he withdrew less than that amount, less than the customary amount, approximately $10,000 a month for marital expenses during the time he was undertaking these business expansion ventures?
Your Honor, the only evidence about the kind of money that was withdrawn is Bonnie's testimony at trial, where she testified that the loans taken out for the business affected what they did and how they traveled, and that they had to make a lot of financial sacrifices to offset the business expansion. That testimony at trial went uncontested. Jerry never put on any type of evidence to show, no, actually, we were living at the same standard. I was spending just as much money on the family as I was before. But even so, the question of whether the family's standard of living went down really isn't the central issue here. Because the fact of the matter is that by depositing all of his earnings into that Cascade Dental account and then spreading some out to the joint checking account that he shared with Bonnie, spreading a small salary out to his own account, but then using that Cascade Dental account to pay all of the family's expenses, that made the account marital property. Yes, Judge Harris.
You just said depositing all of his earnings into that account. What do you mean by the phrase "his earnings"? Isn't the money going into that account the earnings from the business?
And I'm sorry, that might have been a misstep or a misspeak on my part. You're right. It is the earnings from the business. It's the earnings from his dental services. But the fact remains that once they were there, he was using that account as essentially his own personal piggy bank. That could be spent on whatever he wanted. And he did pay the business expenses through that account. But rather than taking draws or taking anything with any type of accounting from that account to convert a certain portion of money into marital assets, he just continued to use that account to pay directly from it. Ms. Nelson brought up the fact that this was an S corporation and that an owner of an S corporation could take draws and could take directly from his business account. And that is correct, but that's not what happened here. There's no record evidence that shows that he was accounting in any way for the withdrawal from his business of these marital expenses. He was simply using the business to pay marital expenses. So, I'm sorry, Your Honor.
But that's all traceable, isn't it? I mean, you can look at the withdrawals out of the corporate account and figure out whether they were used to pay a hygienist or whether they were used to pay for a family vacation or a mortgage. Can't you? Isn't that all traceable? And if so, then why isn't the answer what Judge Hagen's question earlier to Ms. Nelson about assessing him with more income than he claimed he had? I mean, he said he only had $6,000 a month of income, but it turns out he's taking out a bunch more money to pay for household expenses. Why isn't the answer just to saddle him with a higher income figure? Why is the answer to turn the whole business into a marital asset?
The reason that we turned the whole business into a marital asset is because he was using that money that was the family's money. He was using that account that he'd spent on the family and then turned around and used that to augment and to benefit his separate property. In terms of whether we can trace that money and whether we can trace what came in and what came out, I think it's possible to do that. But what's important here is that Jerry didn't do that. And I want to look at just the factual description from the Kiter case, because I think that describes the situation that we have here. The court there described the financial situation in Kiter as the husband's marital earned income would be deposited along with his separate earnings into his personal account, medical practice account, or defined benefit plan. Then both business and personal expenses would be paid from those accounts without regard to what was properly paid from such account. And in that case, the court said that all of that income, whether it was deposited into the personal account, the marital account, or the defined benefit plan, all of that was marital property. So when the husband paid for a piece of real property and paid to maintain that real property, then that real property became marital property as well. That's really the same situation we have here. Jerry's depositing some money into a joint checking account with Bonnie, some money into his IRA, some money into his own personal checking account, and some money into the Cascade Dental account. But then he's going on to pay his family's expenses without regard to what account those expenses should come from and without regard to where they came from. He simply takes money out of Cascade Dental whenever he needs it. And for him to turn around then and to improve that business without any type of accounting and without any type of attempt to keep those funds separate, that turns the business into a marital asset under our case law. Now, before my time runs out, I do want to take some time to talk about the second issue, and that's the award of pre-decree expenses. The district court was well within its discretion to award Bonnie her pre-decree expenses. Jerry's argument is that this should be treated like alimony or it should be treated like property distribution. And the reality is it's neither. The case law underpinning for how we deal with pre-decree expenses is in Dahl versus Dahl. And that case said that it is improper to allow one spouse access to marital funds to pay for reasonable and ordinary living expenses while the divorce is pending, while denying the other spouse the same access. In this case, the district court was righting a wrong. For many months after the couple separated, Jerry continued to pay Bonnie's living expenses. He would deposit $6,000 per month into an account. Then at some point in time, he reduced that to $4,500 a month. Then, justifying that he was paying the lease on a laser for the Vim business in which he did have a 10% interest, he reduced her payments down to $2,000 per month. And then he ended up cutting her off entirely. He stopped paying her any support while the divorce was pending. Well, Dahl says that you can't do that. So what the trial court did was the trial court took Bonnie's reasonable monthly expenses, it calculated her reasonable monthly expenses, and it calculated her earnings, and then required Jerry to cover the difference and to reimburse the difference in order to put her back on the same footing where she would have been entitled to use the marital funds to pay her expenses. There's certainly nothing improper about that, and the district court was well within its discretion to do that. The district court did. Oh, yes, Your Honor.
Can you address the argument that Ms. Nelson makes that even if the district court was correct to do that, it shouldn't have required Mr. Brown to pay 100% of those costs? He should have required Mr. Brown to pay 50% of those costs because those costs, according to the Dahl case, should have come out of the marital estate pre-division. What do you make of that argument?
To begin, the district court didn't require Mr. Brown to pay 100% of those costs. The district court offset Bonnie's living expenses by her own income that she was making, and also by the money that she was able to make by selling one of the lasers. It took a $10,000 deduction from Bonnie's award because she was actually able to sell one of the lasers. In terms of whether these should be considered as marital debts to be addressed in the property division and that this should have been taken out pre-division, I don't know that Dahl gets that far. I think that this is a simple idea that both spouses should be able to use the marital assets, including the couple's monthly income, to pay their monthly expenses. And the court here was right to do that. Yes, Judge Hagan.
But if they had followed that course that they talk about in Dahl, and that both parties were using the marital assets to pay their expenses, then in effect, what would have happened is that all would have come out pre-division. So isn't that sort of, if we look at the ideal situation where both spouses have access to the marital accounts to pay all of their expenses, then the result of that is going to be that the marital estate is reduced by that amount before it's divided.
That's correct, Your Honor. If we assume that the marital estate is not something that's in flux, I mean, this is what we're talking about is just monthly living expenses. Jerry continued to make money. Bonnie continued to make money. There's no indication that either of their expenses were actually reducing the value of the marital estate. I mean, certainly they weren't. They weren't saving money and squirreling away money at that time, but there's also no evidence that they had been doing so beforehand. It's not that this was one big one-time debt that the Browns needed to divide pre-divorce. This was just their ordinary monthly living expenses, and it was appropriate for the court to right the wrong that had happened when Jerry cut off Bonnie's access to that account, and then when she filed for temporary orders, when Jerry misrepresented to the court his income and his expenses to avoid paying her temporary support. It's certainly supported by the evidence at trial. Jerry testified at trial that he had the ability to pay what Bonnie was asking for, and it was well within the court's discretion to award her that. I see my time is running out, Your Honor, so unless the court has any other questions, I will end here. Thank you.
Thank you, Mr. Brown. We appreciate your argument. We'll turn the time back over to Ms. Nelson. 4 minutes of rebuttal.
Thank you, Your Honors. There are a couple of things that I think have been lost. One is the element of intent. Intent is throughout our case law that we need to look at what the owner of the separate property intended. And the trial court didn't make any findings on intent, and I think the intent could not be more clear that Jerry intended to keep Cascade Dental separate except for the things that he withdrew for the family. Our briefs are filled with factual descriptions of Jerry keeping that money separate, Jerry making sure that Bonnie didn't have access to it, Jerry making sure that Bonnie didn't even know how much was in it. That all shows his intent to keep Cascade Dental separate, except for the things that he withdrew. And that leads us into Kiter. In Kiter, it's really important to notice that the thing that was at issue was not Dr. Kiter's medical practice. The thing that was at issue was things that Dr. Kiter had bought. He had bought a piece of real property with some money from his medical practice, and he had bought an airplane with some money from his medical practice. And he also used marital income to finance the real property and the airplane. There is no discussion in that case. There is no decision in that case about whether Dr. Kiter's medical practice became separate. So the part that Mr. Brown read refers to the accounts where Dr. Kiter had taken money from his medical practice and money from his separate accounts, his marital income, everything that was going into one pot. And out of that, he paid for the airplane and he paid for the real property and he paid for all these other things. Well, of course, the real property and the airplane became marital. Of course they did. It's hard to even see how they would not have. But the medical practice didn't. And Jerry Brown's dental practice was the same way. It was in one container. It was in the Cascade Dental container until those dollars left. And once the dollars left, they became marital, and anything they bought became marital. Now, whether there was an accounting, that's not part of this analysis. That sounds like a commingling analysis, and Judge Harris brought up the traceability. Well, the trial judge here specifically said this is not a commingling case. And that's important, and it's completely correct that this is not a commingling case for the reason that Judge Harris pointed out, which is that every transaction here is easily traceable. Now, whether Jerry was making sure that every month he withdrew the same amount, I don't see that anywhere in the case law. That appears to be what our opponent thinks is necessary, but it's not in the commingling case law, and it's definitely not in the whether marital funds were expended case law. Just a few seconds left, if there are no questions, just a few seconds left on Judge Hagan.
I actually do have a question. So what if instead of he let's say he withdrew about $10,000 a month to pay for the mortgage and the car payments and all of that, But then instead of leaving all the rest of the money in the dental account, he put some of it in an IRA. So it never, it was never used on marital property. The IRA would be marital property, right?
Yes, and in fact, I think that's what happened in the first divorce. I don't remember. My facts are a little fuzzy on that, but I think that is what happened. And
but then how can a spouse skirt or avoid that by just, instead of putting it in an IRA or in another account, just leaving all of that money, a nest egg, if you will, for their retirement in the business itself? How is that? Is that equitable?
Well, first off, if this was simply there is an equitable exception here, right? The trial judge could have used the equitable exception to divide this property, and he did not. He used the marital funds exception to divide the property. So is it equitable? Yes. But anyway, it's equitable, yes, because the rule is that your separate property stays your separate property unless you intend to do something differently. So if we don't like that rule, well, we can talk about revising the rule, but that is what the rule is. Your separate property remains your separate property unless you intend otherwise. We have cases where people take some money out of their inheritance and help buy a house. Well, that's a gift to the marriage. Is it fair for them to keep all the rest of their money in their inheritance? Sure, why not? And I think that if we start I think it's easier to see it with inheritance, but all of the case law suggests that inheritance and separate property would be treated separately. And
let me add on to my hypothetical. So in my hypothetical, Jerry creates this IRA. It's only in his name, and doesn't ever tell his wife about it. So he absolutely has the intent to still keep the money separate. Is that still separate property, or is that marital property?
I think at that point, we would need to be talking about assets that were accumulated during the marriage, but that's not what we're talking about. We're talking about Cascade Dental that stays Cascade Dental. We're not talking about money leaving to go to any type of new account, right? And that's where Kiter was different, because in Kiter, the money did leave the medical practice to go buy the property or to go buy the airplane. And the IRA that you're describing sounds to me like that real property or that airplane, but not the medical practice itself, and here not the dental practice itself. Those dollars stayed in there. They didn't become Jerry's dollars until they were transformed, until they lost their identity as Cascade Dental dollars and became something else. Otherwise, they stayed in there. Is that fair? Yes, that's what the separate property rule holds. I see I'm out of time. If I can just say a word on the last issue about the credits, we just see that Jerry was given no credit for the money that he continued to pay on Bonnie's behalf, which is not disputed. They agree that he paid the loans on the $100,000. They agreed that he paid the loans on the laser, and he was given no credit for that. I will end there, Your Honor. Thank you.
Okay. Thank you, Ms. Nelson. We appreciate the argument. Thank you as well, Mr. Brown. I think this case has been well argued today, and we appreciate you coming to our virtual courtroom today to help us understand this case a little bit better. We will take this case under advisement and get a decision out to you as soon as we're reasonably able to do so. And we'll be in recess.